I'm here with Lisa Peterson, Wisconsin Underwriting Counsel, and Wayne Wench, Wisconsin State Counsel from the Fidelity National Title Group, which encompasses Chicago Title, Commonwealth Land Title, and Fidelity National Title. Today's title topic is Wisconsin Homestead Law. Who signs the deed or mortgage?
It's important to know who has to sign a mortgage or a deed to make sure that that mortgage and deed is going to be valid and the interest of the grantee or the mortgagee is insurable by title insurance. Every title insurance agent has to know that. So we're going to talk now about whose signature is necessary on the deed when the title is held by a married person. So just by way of background, the bad news for many of our customers who come to the closing without asking us to invite their spouse to come along with them is that the closing has to be canceled. If you look at Wisconsin history and Wisconsin law, there's a statute of frauds which requires that before a deed or before a mortgage or deed of trust, as it's called in some states, is valid, the deed has to contain a property description, it has to be signed, it has to identify the names of the parties, and it has to be joined in, it has to be signed by either that document or by separate conveyance, the non-title spouse. And that requirement is what we call the Homestead Law. So why would a state legislature make a law that would require the non-title spouse to co-sign a deed or to co-sign a mortgage for the deed or mortgage to be valid? And the answer has to do with Wisconsin history. When this law went into effect, the same law that's in effect today, unfortunately, was enacted in the 1840s in Wisconsin. The primary asset of every person, not just married people, but every person in this state, was farmland. And because the public policy of the state was thought to protect the formation and retention of the family unit, it was made into law that the family patriarch could not sign a deed by conveying the farm away without the consent of his spouse. That law is still in effect today. Does it make sense in today's economy? And Lisa, I'm going to ask you several questions that bring us by fast-forwarding the law to today. When it's necessary for the non-title spouse to sign the conveyance.
I'm ready.
So what about when the title is held in the name of John, and John wants to purchase by getting a mortgage loan, purchase property and sign what we call a purchase money mortgage. In other words, a mortgage that's to be used to finance his new house.
Well, the good news for John is that is the one exception to Wisconsin's homestead rule. A married person can take title alone and sign that purchase money alone. And the reason behind that particular carve out to the homestead exception is so that it encourages people to actually buy homes and establish homesteads. And it may be the case where one has bad credit, so you only want the good credit spouse to come into title and to sign that purchase money mortgage. So John, a married person, can take title to homestead alone and sign the purchase money mortgage alone. But I bet you have more questions because after that, everything changes.
I have a second question. What if John and Mary are married? However, the title is held just in the name of John. He was the grantee in the deed, all by himself. He's still married to Mary. Their divorce is pending. Who has to sign the deed?
Well, if it's homestead property, I'm here to tell you that just like you can't be a little bit pregnant, you can't be a little bit married. You either are or you aren't. So if you're merely in the process of a divorce, you're still married. So Mary has to sign that mortgage, or the deed for that matter, on that homestead property during the pendency of the divorce.
You're tough. Third question. We have two high net worth individuals who are married to each other, John and Mary. They both went to the best attorneys that money can buy to draft a marital property agreement that set forth the rules for their marriage. They're so special. And after having this marital property agreement drafted, they defined Mary's house to be Mary's sole and separate property. John has no rights in Mary's property, but John gets to live in that house. Mary now wants to refinance her mortgage. Who has to sign the mortgage?
Well, sorry, John. Sorry, Mary, both of you. Even though you spent all that money on a marital property agreement, marital property and homestead property are two different concepts in the law, and we will not rely on a marital property agreement, prenuptial agreement, antenuptial agreement, whatever fancy word your lawyers call it, in order to forego the signature of one spouse. So if you're married, even if you have that marital property agreement, if only one of you is entitled to the homestead property, you still both have to sign either the deed or the mortgage. Again, unless it's a purchase money mortgage.
Fourth question. We now have two millennials, John and Mary. They're young, in their 20s or 30s. They just got married. John owned a house all by himself. Mary has never set foot in the house. John now wants to sell the house. Who has to sign the deed?
I just had that exact question this morning, and the answer is they both have to sign the deed. Because again, once you get married, if what you're dealing with is your homestead property on a sale, a refi, or an equity deal of any kind, if you're married and it's homestead, you both have to sign the deed or the mortgage, even if she's never even seen the pink shag carpeting in the bedroom.
Okay. Fifth couple, John and Mary. I think these are probably high net worth individuals, or perhaps they're set in their way individuals. John lives in La Crosse. He likes Oktoberfest. He wants to stay living in La Crosse. Mary lives in Minocqua, Frostfest, and she likes living there. They both have great houses that they acquired before their marriage. Mary, living in Minocqua, wants to refinance her mortgage. Who has to sign the mortgage?
John and Mary. Because even though they each have their own homestead and they each have separate houses and they're titled completely separately, if they're married and it's Mary's homestead, John has to sign. Flip is also true. John's property, if it's his homestead, Mary has to sign. So even though they have two houses, two deeds, two homesteads, the law says if it's his homestead, it's her homestead, notwithstanding anything else you may want to claim.
Okay, you're not making any headway
I know,
with you
sorry.
here, Lisa. You're really extremely rigid in your approach here. Sixth and last couple, John and Mary acquired the title by land contract, installment land contract, which is a common financing device used for people who find sellers who are willing to finance their property, the purchase of their property. They acquired the title 2 years ago to their house. Now they want to refinance by paying off the vendors under the land contract. They're going to Bank of America for a mortgage loan. Who has to sign the new mortgage?
If John is entitled alone on that vendee's interest in land contract, they both have to sign. Because remember, the purchase money mortgage was the land contract. So now when they're going to an institutional lender, or any lender for that matter, to refinance that land contract, it is just that, a refinance. I think sometimes people forget that the land contract operates as the purchase money mortgage, and any financing after that requires both signatures on Homestead. I think our last scenario that we forgot, which we were going to touch on, is legal separation. What if you have a couple who is in the process of a divorce and they actually get an order of legal separation? In other words, signed by a judge. Not just Dwayne and I are separated, but we have a legal order of separation executed by a judge that they bring to us. Does that change the outcome on Homestead? Now I'll quiz the teacher.
Yes, it will, because if there's a legal separation judgment, the judge has decided that John and Mary each have their own distinctly separate homestead, using the legal jargon, and that means that Mary can refinance so long as she's the sole title holder. She can refinance her mortgage on her house without having her husband, John, to sign in. Because why? Because they're legally separated by the judge. Don't confuse that with the fact that after people are thinking about divorce, they move to a different location. That's just a de facto separation. That's not a legal separation. I get a lot of people telling me we're legally separated when in fact they didn't go to the point of filing a legal separation proceeding with the court and get legally separated.
And while Dwayne and I made light of this topic because it's a heavy topic, understand that this is probably the single most important thing that you have to get right when you're insuring a deed or a mortgage. Because the punishment, if you get this wrong, is the document, whether it's a deed or a mortgage, is void, which means it has no legal significance. There's nothing to insure. It's not a valid lien on the property if it's a mortgage, and it's not a valid conveyance if it's a deed. So follow these rules to the letter of the law because it is that important. And for more information on this one, you can also check our webinars on the National Agency website. So with that, we would like to say that these are the opinions of Dwayne and Lisa, and those are the Fidelity National Title Group. Thank you.
Thank you.